All right, I'm going to give everybody just a moment to get started, but welcome everyone, and thank you so much for joining today's webinar. We are very excited to have you with us. Later on in this webinar, you're going to meet our amazing partners over at HMR, On Point Legal Nurse Consulting, and Fox AE. We are so grateful for all the things that they do for us here at Connectionology, so that way we continue doing these webinars for all of you. We have a very special guest today, and it's Eric Fong, and I can't wait for you guys to hear from him. He's incredible. And then Cash is going to be our incredible moderator. I'm going to go ahead and get started because we have a lot that we're going to be talking about. And if you have any questions, please put those in the Q&A box, and then we will kind of ask them throughout the webinar and make this pretty conversational. But let's go ahead and get started. I want to introduce our moderator today, Cash. You guys have probably seen him before on a lot of webinars that we've done in the past, but he's here today as one of our moderators, and he is from Seattle. And he began his career in a small personal injury firm in 1986. He later left private practice to gain trial experience as a prosecutor. And he had a brief tenure at an insurance defense firm, and that is when Cash opened Cash Sessler PS in 1991. So that means for the past 20 years, he has been dedicated to representing individuals in criminal defense as well as personal injury cases. And one of the things that defines the advantages is that he has worked as a prosecutor and as a criminal defense attorney and an insurance defense lawyer, as well as a personal injury attorney. So his experience working on both sides of the issues has been able to help him understand a lot of the strengths and a lot of the weaknesses of each of his clients' cases. So as a criminal defense attorney, he knows from experience that prosecutors respect attorneys who prepare each case as if they're going to trial. And so that is the approach that he takes with every single case. So he has personally and successfully represented hundreds of individuals charged with a variety of crimes across Washington. And that's been over the last 2 decades. And if you're lucky enough, you've had a chance to meet Cash because he actually goes to a lot of these conferences all across the country. One of my personal favorites is running into Cash when we go to the National Trialers Seminar every year in Miami. I hope that you guys will get a chance to meet him at some point. But today we are just so honored to have him with us. And Cash, it's such a pleasure. I'm gonna go ahead and hand the webinar over to you, and let's have a great webinar. And I went ahead and unmuted your line. There we go.
There we go. Thank you, Ginger. I want to thank you too for organizing today's presentation. Everyone should know that you're the executive director of Connectionology. That's a position that you've held for over 5 years now, and you're doing a fantastic job. You organize all of us, you schedule us, you coordinate us, you put together all the advertising out for this, amongst other duties. And every time I'm part of a presentation, when you're leading it, it's just been so smooth and so professional. So thank you. Thank you so very much.
Thank you, Cash.
And then I just also want to jump out front and say thank you to our sponsors. We wouldn't be here today without them. They're invaluable resources for our day-to-day practice. And by helping sponsor these Connectionology webinars, they're helping us to be all better lawyers. So thank you to Fox AE, HMR, and On Point Legal Nurse Consultants. Now, let's move on to the main course. I want to introduce to you Eric Fong. He is a superb trial lawyer. He has decades of experience. He's tried over 100 cases to a jury with monumental success, and he's humble enough to admit failure as well. He practices in Washington State, and he's willing to travel to wherever clients need him. And he's done that at least 7 times. He's practiced in 7 other states besides Washington. He tries both criminal and civil cases, and he tries them both with equal passion and sophistication. And one of his proudest accomplishments, and one that we should all be thankful to him for, is that he established the constitutional right to intimate association in the state of Washington. And that's a case that he started in district court as a misdemeanor. That's the lowest court that we have besides small claims court. And he took it all the way up to the Washington Supreme Court to make sure that he got justice for his clients and really for the rest, all of the people of the state of Washington. So thank you for that, Eric. Also, you should know that he's been a teacher at the Trial Lawyers College for over 16 years now. He's very passionate about his topic today, using emotion in the courtroom to reach the jurors and to get justice for his clients. So, Eric, the microphone is all yours.
Right on. Well, good afternoon. I guess we're here to talk about emotion and logic and how to move people and how to I guess get folks to arrive at a safe place to make a decision. And I guess we're talking about in the context of a jury trial. But I think we could certainly be talking about it in the context of everyday encounters, whether you be at the grocery store or your significant other, or you want to make a business transaction or take a bid on how to build a house. And I guess, Cash, I don't really know where to start other than to say, if we're walking into a courtroom, and it could be a simple hearing to continue, or it could be a super complicated summary judgment motion, or it could be the first moment we're going to talk to a jury, we are bringing with us a huge baggage of logic. And we're bringing with us this insane agenda of things that we want to accomplish so that we can win in court. And what gets lost in all of that is what's going on with not just the other person, but everyone in the environment. You know, people that are critical to making the decisions. And sometimes it's triangulated, you know, particularly in a jury trial where you have a judge, you have a witness, and you have the jury, the defense lawyer, and you have this insane web of relationships. And I think we spend so much time as lawyers hyper-focused on the intellect, the logic of putting our cases together, of checking off the boxes of the law, you know, the dirty ins and outs of what we were trained to do, that we lose sight of what really matters and what drives decisions, which is feeling. And, you know, connectology, I love the name connectology because I guess it's based on this idea of a relationship that gets formed in the courtroom. And I unquestionably believe that decisions are arrived at a relationship, both the ruling from the court and from a jury. And relate group, so in the context of a jury trial, group dynamics in how that group is going to relate to each other when they go back to deliberate is going to be in large part determined by the relationships that are developed through the course of the trial, starting with my relationship with the jury. And the group is built one relationship at a time. So there you go, man. That'll get us going. And you know, there's endless topics that we can cover. So I guess I'll just throw it out there. And
how do you establish, you're talking about, you have to establish it with the jury first. And I'm sure that starts the moment you walk in the courtroom and you still have the voir dire panel. But how do you consciously go about establishing that relationship?
So those of you that are familiar with role reversal is a really simple tool that is critical to understanding relationships. And role reversal is simply trying to imagine what it's like to be you, Cash. And so what would it be like to be someone listening to this right now? And if I were to reverse roles with you, I would imagine that there's a little bit of pressure. You have to run a conversation. You have to listen really intently to what I'm saying. You have to vibe off it and kind of create a riff that is of value to the people that are listening. If I was to role reverse with, folks that are out there listening, I could imagine that there's some curiosity. There's a lot of interest in what may happen, but there could also be other things pulling at them of what needs to be get done and the sacrifice that people are making to listen here right now. And so if I can walk into a courtroom with a jury and I see 60 people looking at me, and I try to imagine, like, genuinely, what is it like to give some care to what it's like for each one of those folks? I believe that there's a parallel universe of communication. And in my intention of trying to understand other people, they will naturally try to understand me. And through the respect of that interaction, relationships are beginning to be formed. And this is going to sound maybe goofy as hell. Maybe it makes perfect sense, but I will sit down when people walk in, and it's scary as get out. And everyone who's tried a case knows that feeling when you're standing there and a wave of people are walking in and everyone's staring at you. I will sit there and meditate to myself and look at people and say to myself, I care about you. I really want to know what you have to say. Would you like to know what I have to say? And I want to be your friend. And so I'm putting out an approachable affect. I'm intentionally trying to make myself open to form a relationship. And another way of, the contrast of it is people are walking around always getting in fights and they don't know why. And they're carrying with them this anger and this aggression that is coming from some place inside of them that they don't even understand. And that vibe is fed off by people they don't even know, and it creates that relationship. So, Cash, this is a really long-winded way of answering your question, which is, I'm just putting out kindness. I'm just trying to model good human behavior that is based on respect, understanding, and appreciation for the folks that I'm encountering. And what gets in the way of me doing that is when I go into court, I have in my head all the logic. I have all the thoughts. I have the agenda of what I need to accomplish in the areas of the law that I need to have a discussion with the jurors so that I can pick a fair jury, right? And the two are not they're not really helpful for each other. And so, it's just we're trained to go into court to strike people we don't like. We're trained to go into court to identify the people that are hostile to our causes. We're not trained to go into court to be likable and to be friendly and to be respectful.
So, okay, so you're there. You're trying to put out that you're a friend, or that you kind of understand all the stress that they're under, and we're trying to make this work together. The last trial I had here in Washington, I had 20 minutes for a panel of 30 people to start asking questions and to sort out who I wanted and who I didn't want. I'm going to have to ask questions. Do you change your questions at all based on what you've just said? Do you ditch the questions, and what?
So what happens under those circumstances is your mind starts racing
Mhm.
Inevitably the juror that has a lot of baggage starts talking, and 2 minutes later you don't really understand what they're saying, and you're like, my God, I just lost 10% of my time. And the anxiety starts to build inside, right? And that's devastating to building a group and being a leader. Our anxiety is palpable, right? Our energy that we're putting off, the tentacles and the receptors that we have, that the emotion is reading, is undeniable. And if I have 20 minutes, I figure that I've got, including the introduction, I've got 3 topics I can cover.
Okay.
So the introduction, when I first meet a group of people, we have to meet people where they are. We cannot, I don't know how to explain that, except that when you're aware of emotion, particularly yours, you have an increased chance of perceiving where other people are at. You can hear it in their voice, you can see it in their eyes, you can hear how they answer questions. And what I do know is that 40 people being pulled out of their houses in order to show up in court is not fun. And so I have this this introduction, I've done it over and over and over again to break the ice, because if I'm nervous, I know they're nervous. And in building a group and empowering the jury, and maybe as we go along today, we can talk about empowerment. But our job as a trial lawyer is to build a group of people that are empowered to do justice, to go out and do great things. And as a group, do something together that they could never do on their own. And we can't just come out with that all, patriotic and on fire and come out saying that stuff. It has to naturally build up. If we do it too early, we're not meeting the people where they are. We're unloading our stuff of what we want to accomplish on them too soon. We have to build up the energy and the emotion so that they get there naturally without us ever having to say it. And so the first thing I'll do when I meet a group of people is first of all, thank you for showing up. Every one of you made a big sacrifice to be here today. And what I'd like to know is how, when you opened your mailbox or you went to your PO box and you saw the county envelope and you opened it and you saw the summons to be in court for jury duty, how did you feel? How many of you were like, hot dog, this is awesome, I can't wait to go? Or maybe you were like, I can't believe this is happening right now. I have a job. I got to take my kids to school. I'd like to hear from some of you. So that's a natural way to break the ice and to get people kind of meeting them where they are, right? Where they are is they don't want to be there. They're surrounded by strangers, and we're going to start probing about personal things. We have to make it approachable and safe to talk. The next thing I'll do in the introduction is to start the empowerment process, which is, if you look around right now, the 60 of you that showed up are special, because thousands of these summonses went out to every registered voter, people have driver's license in this county. And I don't know the statistics and numbers, but a lot of people, once they opened it up, they just threw it away and never even bothered to show up. But you showed up. And I'd like to know why. Why did you come? And it's a feel-good conversation of it's a duty, it's a responsibility. It's my civic duty to be here, right? That will naturally come out of this discussion. And now you're building up the importance of these people. And what do we like to hear the most about? Me. I want to feel important. I want to be acknowledged for what I did. So I'm now, right, warming up into a group. And of course, as the trial lawyer, we need to be the leader, the Sherpa, the teacher, the guide that can be counted on to safely maneuver this really weird and foreign place and environment. So in a very kind of friendly, open, and respectful way, I'm intently listening as I go through this process of group building.
No, I like that. You're hitting some of the stuff that I do, but you're making the jurors give it to you.
Right.
No,
And that's the key. You know, there's this saying, the more we're talking, the less the jury is. And of course, a good trial lawyer is not saying much, but getting the jurors to talk. And the excellent trial lawyers are getting the jurors to talk in a way that advances their case, makes their arguments for them. And when the trial lawyer is talking, it is igniting stories in the jurors' minds, the context that is, the frame, the argument, the justice that we need and want.
okay. So I'm assuming you have some other empowerment questions that you throw out there.
Well, that's sure. And so we got 20 minutes to pick a jury, right? You have to break the ice and start. And I don't care if you have 2 days to pick a jury, I would still open up the salvo and the group formation and the conversations in the same way. And I've mentioned, how many times have I mentioned group formation? I cannot stress enough the understanding of group dynamics. And I don't know how much people are going into this or thinking about it, if there's lectures on it. But within group dynamics, and the relationships that get built within the group, within a veneer, a group of people that are coming in to be selected as potential jurors to decide justice, there is, I think, a widely understood and studied concept of followers and leaders, right? And the group dynamics are altered radically by the composition of who these folks are. And as we are talking to a group of people, we have to be keeping track in our minds, through the demographics that the court, the juror qualification notes of who they are, what their jobs are they in leadership positions, how do they look, what's their education, how do they communicate? You can Google leaders and followers, but we're extracting, as we communicate with the jurors, we're assessing, the composition of the group and what it might look like. And we have to keep track of our strikes so that we know who we want to use those on. And a bad juror that's a leader is who you want to strike. And an unknown juror that's a leader, I would strike before a bad juror that's a follower. That's why you don't want a lawyer on your jury, because it's a leader that will have an undue amount of influence over the group.
That makes sense. Do you try to limit the number of leaders on a jury? Do you try to step a couple of, 2-3 leaders and the rest followers? I mean, obviously every jury you're stuck with the dynamics of who's there, but
yeah, I don't know if I'd break it. I don't know if I'd go so far as to say I would want to limit it other than there are, I call them venomous jurors. that their behavior and their interaction with me is just bitter. And you can trigger folks, by the way, right? There's topics that you can ask a really innocent question on that will trigger people. And I think a really great question that we could ask in every single trial for money is, how many people think lawsuits are driven by greed? How many people think that the size of the verdicts today are outrageous? And people are going to raise their hand. We know out of the gate that anyone who raises their hand to that question is someone that we should look at very carefully. Just because they raise their hand to that question doesn't mean they're a bad juror. The ones that talk to you and they come out like brimstone, fire, and hot of why the system is broken, and lawsuits are out frivolous, and my back hurt, no one ever gave me money, and there's like this bitterness to it. That's the juror that you will never win over. And what you want is for that juror, if they're on your panel, to not talk, and the follower will shut down, whereas the leader will be vocal.
Okay.
And you want your bad jurors to not talk. And so I don't know if it breaks down to how many. You want as many leaders that are good for you as possible. You want as few leaders that are bad for you as possible.
So do you come into court when you're picking a jury, going back to the very beginning, we're taught to strike certain kinds of people, and you've just identified not, I'm going to strike someone because they're, well, you did say lawyers. We don't want lawyers, okay? Are you going to, in a criminal defense case, are you going to strike teachers? Are you going to strike doctors or medical professions? Do you still like sort out amongst professions and say, if I have a choice between this juror and they're a follower because they're a teacher, I'm going to get rid of them? Or
this is a, I mean, I think that what people need to learn is how to try their case and how to behave and try and pick a jury, because there are unbelievable ideas and examples of lawyers that are pros at striking. Like their whole jury selection is designed at identifying the for cause strikes and maximizing that, and to stack the jury. I don't do that. I pick a jury of inclusion, and I'm not naive and I'm not stupid, and I know there's people I want to get rid of. But I do focus groups, so I will learn in advance, the types of people I want or don't want, and I will zero in on questions that will trigger people to identify the folks that I want to try and get for cause or peremptory. Having said that, there's general rules of thumbs that doctors you should be leery of, engineers, the money and the technical aspects of it, and quantifying things into small amounts you don't want. And so other than, the answer to your question is yes, and that's a really lousy way of answering it. But what I really want to say is I am more concerned about establishing myself as just a normal person that wants to genuinely understand your points of view, and I want to respect it. I don't want to disagree with it. I don't want to kick you off because you're not going to be good for me. I just want to get to know you, and I want to know if you're someone that's good for this jury or not that should sit here.
I think we're going to have a break here in just a second, but let me ask you one of the questions from the audience. The question is, I was listening to someone who was emphasizing what you focus on, you make important. And I know we need to get out the bad info and find the bad jurors, but how do you temper the bad with the good?
Absolutely. I think that we need to own the bad stuff and come out with it as soon as possible. And picking a jury is a great time to do it. And identifying the parts that kill us, that we don't like, the facts that, if we lose that issue, we lose the case. If we don't know how to deal with that and own it and be comfortable talking about it, we're probably going to lose the case. And maybe after this break, we can go deeper into that. But I think dealing with the bad parts of the case is critical to being a great lawyer.
So I see we have Cody Roberts up on the screen from Fox AE. And
Yash. Hey, thanks for
hi,
this.
how are you today?
Doing good, man. How are you doing?
I'm doing great. So
Good.
let me introduce you. This is Cody Roberts of Fox AE, and AE stands for Animated Engineering. And so Cody is, he's on the cutting edge right now of courtroom illustrations. It's amazing the work that he's just been putting out. He brings an engineering degree to his graphics, and he's just detail oriented like you wouldn't believe. And then he just comes out with these great ideas and new illustrations that he's spoiling us now as trial lawyers. At the last conference in Nashville for Connectionology, he had a 3D human head model. And basically, he said, look, I can take your client's head and put this on the model. And you see that your client's facial features, you see their eye, the eye color is correct. You see this head blinking back at you. And then you realize that part of the skull has been removed. And there he's showing in 3D detail the injury to the brain. It's just fantastic. And that's just one of the new crazy illustrations that he has. He has so much to work with. So you should basically reach out to Cody and find out what he has. If you have an idea, you can give it to him and he can create it. So Cody, take it away. Tell us more about what you do.
Yeah, thanks, Cash. And by the way, it's really fun hanging out with you at these conferences. Like I have become friends with a lot of these attorneys, and who knew trial attorneys are people, and they have emotions, which is what you're talking about there, Eric. And so it's great because they're people, it's so fun to hang out with people like you, Cash, and you just make it so nice. And Connectionology was awesome. So yeah, we do graphics. And so what we like to do is we like to tie the cognitive, the logic in with the emotion simultaneously. And I want to give you just a quick example of how we did that with a product defect case that was an engineering manufacturing defect. Actually, it was a design defect. And let me see here if I can share my screen. All right, can you guys see that?
Yes.
Okay, so 11 similar accidents happened within this year where it was throwing people into a propeller, okay? And what happened was this center of gravity, this is the cognitive portion, Eric, that you're talking about. The center of gravity was near the rear of this boat. That's how it was designed. And so you have a front seat and you have a lack of seat railing and this was a kind of a high-end fishing boat for marsh fishing, if you like redfish. I'm from the New Orleans area, so I really enjoy that kind of thing. But the father, here's the emotional part. Father was driving, son was in the boat. And what happened was, this is the 11th time this has happened this year, throws the son Tyler into the boat propeller, fingers come off, hands chopped. This ended up being an amputation case, okay? At big time damages. And the thing about it is, we go back from emotion to cognitive. Okay, hold on. So the engineer designed that. What could they have done differently? Pennies on the dollar. This is a high-end fishing boat. Pennies on the dollar. You can add aluminum railing. Now, we matched the G-force with the rotation. And so this is the exact G-force that the boat turns. And then we're demonstrating that Tyler would still have his hands. And so, you know, medical stuff, engineering stuff, you know, we love it. And we love mixing cognitive with emotion. And, you know, if it really gets the jurors going with anger, fear, compassion, empathy, and it teaches simultaneously to the expert witness what they're trying to say, then it's a successful demonstrative in my opinion. So that's what we do.
You know, I just a good illustration could almost be your opening statement. Like, what would anyone have to say if you watch that? And by the way, anyone who's been on a boat, I'm an avid fisherman and boater. You know, the violence of that turn is well known to everyone. You can catch. It's kind of like snowboarding. You catch an edge, and the boat can rapidly turn. And there's conditions on the water that make it unpredictable. A product's liability case where all you have to do is put on a rail, for anyone who knows anything about boats and waters, like, there's no way you lose that case. That's outrageous. And then you see the thing, and the only thing that had me on the edge of my seat was he going to lose his head or not, and how lucky he isn't. And so, that powerful illustration.
Well, thanks, Eric. And actually, it's funny you say that. You know, we had a guy who said, "Hey, Cody, I'm using this in opening. We got to make this right. We got to make this great, because it's going to make or break the case." And that's music to my ears, because that's when you know you're in the right business. And I want to contribute that much. I really want attorneys saying that. So that made me feel really good.
And we need to put a caution out there that you need to know what you're allowed to do in opening statements, because you'll be able to show that illustration most certainly through an expert or what have you. But you need to understand judges' propensities to allow you to use demonstrative evidence as an opening. And frankly, even sometimes stuff that's admitted as evidence can sometimes be a hassle to get in opening. And so as we go into court, you know, just practice pointer, know in advance. You can even call up the bailiff and have pre-conference at the pre-conference, whatever, ask the judge, you know, how does this work? So anyways.
Great. Thanks, Eric. Thanks, Cash.
You're welcome. So it looks like we have Blue Edwards up. He's from HMR. And I have to tell you, I learned about HMR years ago, and it was such a relief to learn about it, because I know every trial lawyer has a client who can't afford the cost of a case. We get a good case, and those are invariably the cases where we need to have the most cash flow, and those are the clients that can't help us out. And here in Washington, we are supposed to be very careful about how much we advance in towards of costs, client costs. And certainly I can tell you, I have never advanced money for my client actively treating. And yet I have clients that call me up and say, how am I going to pay for this? Or can I have a loan? And so HMR is to the rescue. So Lou, please tell us some more about your company.
Well, thanks, Cash. And it's good to be here with you guys today once again. Eric, great discussion. It's good to be a part of this. It's always tough to follow Cody because he's got so many cool graphics and just a great guy. So you guys definitely take advantage of the tech that Cody's using. It's extremely valuable. So HMR, HMR is a premier funding source for personal injury plaintiff law, and we are nationwide. So we currently function in 39 states, meaning we work with providers nationwide. You know, doesn't matter. Even if I work with a lot of attorneys that will be, they have a case in another state or another, it's not their backyard, right? And they don't really know who to send their client to for any sort of medical treatment. That's always a good time for them to give me a call. And they're like, hey, Blue, I don't know anybody in Oklahoma. I'm like, okay, I got you taken care of. So that's just a small example of, how we can help attorneys out. I do want to cover three things, three main points with everyone today. First of which is pre-settlement funding. So obviously this is a difficult time for your client, right? Maybe they can't pay their bills, their mortgage, etc. Right? We can step in and help out with that in the form of pre-settlement funding. We do have some of the most competitive rates in the country. Please feel free to reach out if you guys are interested in hearing more about the pre-settlement. Second thing I'd like to cover is case cost funding. And like Cash had alluded to, this has become one of the main points for attorneys. I've been getting quite a few phone calls on this as of late. And what is pre-settlement funding? It's just case cost funding. It's mainly used to help get the experts you need, right? To shore up your case, get some top tier life care planners maybe involved on the case. Anyway, it's just another tool that we offer, the attorneys that we work with to help you succeed, to help you build your case, to help you get the best settlement for you, the client, everyone involved. And last but not least, the third point is going to be medical funding. Like I said, we work with providers nationwide. If you have providers, doctors that you just absolutely love to work with, great. We would love to work with them as well. Don't let that keep you from reaching out to us and utilizing that service. So with that, we do also have a full staff of case managers. We try to make the process as seamless and as quick as possible. But if you guys have any questions, feel free to reach out at any time. Like I always say, I'm always open for business. So I will be sure to leave my number and contact on the message board. And thanks again, Connectionology. You guys always do a great job.
Right on.
Thank you. So, Eric, what's the next thing that you want to share with us?
Well, I do want to build off of, what Blue just said, which is, when we're piecing together our client's story and we're developing the plot, and this ties into the question that Rachel asked, and which is we want to focus on what we talk about is where we're putting the focus on. If the feeling, the emotion that we want to generate is, let's say it's with rights come responsibility, corporate greed, something along those lines, right? That's where we want the focus to be. It's not like we're banging that with a drum and just pounding and nonstop talking about that. What we're trying to do is build energy and emotion through the trial so that the jury will get there on their own. And so there's a fine line between where we spend our time talking is where the jury's going to focus. Because if we spend too much time focusing on some kind of talking point we love, we actually can have an adverse reaction of pushing people away. But if we lay the breadcrumbs out so that the jurors do the talking for us, right, through the subtle framing and storytelling that ignites the imagination of the jurors to get there on their own, then we have built, the momentum we need for the jurors to do our bidding and our killing back in the jury room. And I hope that makes sense. But But let's say it's corporate greed. And by the way, built into that is the legal tactics that this corporation is going to deploy to avoid responsibility. One of the things we can do is, as we're talking about frivolous lawsuits and jury selection, which is always something we have to talk about. So if you have 20 minutes, one of the three things you have to talk about, 5 minutes each, introduction, 3 other points, has to be frivolous lawsuits, money for justice, burden of proof. Those can all be done together. But as we kind of process this landmine of frivolous lawsuits, at the end, we can ask, what's a bigger problem? Frivolous lawsuits or corporate greed? Today in America, what's a bigger problem? And you're going to probably find that everyone would say corporate greed. And that ties in real nicely to if you folks find that I'm frivolous, that this case is frivolous, that my client is willing to come into court and lie, then we will accept your verdict, and we would hope you send us out of here with nothing. But you're just subtly introducing this concept of corporate greed, right? We don't have to go on and on and on about it, because instantly their minds have now gone to the place that we want them to go. Opening statement, it's a theme, right? This is a theme. In opening statements, we would create a story that ignites the imagination of the jurors to go to corporate irresponsibility in some way. And I don't know, you have to spend time constructing your story to as you tell it in the delivery, that it triggers the imagination of the jurors to start filling in the blanks. So we're not hammering away at what we want to talk about. We're slowly kind of bringing this stuff out because we're meeting the jurors where they are, and we're just introducing ideas and concepts. But now we got to prove the case. And now I'm tapping into what Blue was saying. It's like we have to have experts, lay witnesses, and we have to put together a case that is going to stand the rigors of this process. And what I want to say, to support, frankly, because the services that they provide are essential if we can't afford it ourselves, is that we have to be willing to lose everything. God damn it, we as trial lawyers have to be willing to put it all on the line, because it's that important and it means that much to me that I'm not going to compromise my principles and sell my client short and just settle the case. And if that means that we have to borrow money to go into court and have a chance at justice, we have to do it. And what you will find in pushing these limits of what we're comfortable with, and by lining up the experts and thinking the case through of covering all our bases, is that the justice we receive makes that the best investment we ever made. Because we have to win, right? We have to go in and on direct examination, which I find to be the scariest part of the trial, because it's frankly the least amount of control, ironically, that I feel like I have in the trial. But we have to get out of direct examination alive, and we have to check the boxes on the jury instructions. Cross-examination is when the case begins for me and gets fun and exciting. And then in closing argument, we tie it all back in together of what we want the jurors to be talking about: corporate greed. What have we seen in this trial? What have we learned about this defendant? The lengths that they are willing to go to blame the very person they hurt, right? It's not that complicated. So anyways, sorry, that's a little tangent, but.
No, I like the lengths that the defendant's willing to go to hurt the person that they hurt. Yeah, I like that.
Cash, I want to back up a little bit, because there's a question from earlier on that says, has it ever backfired? When I did my introduction and we're talking about jurors, why'd you show up? Thank you. A lot of people didn't. And there was a question of, well, can that backfire? And people will say, well, I have to be here and I don't want to be here, or I'd be arrested if I didn't show up. And I don't think there is such a thing as, I don't think anything can ever backfire in jury selection. The only time a question can backfire is if I'm trying to advance an agenda and someone wants to fight me on that agenda, and in my mind, I have something I have to do. But if we are asking honest questions and we are wanting honest answers back, there's no such thing as a backfire. They may say something that I don't like. They may say something that I totally disagree with. But that's not a backfire. That is an honest share that I appreciate more than anything. And the gift in it is that we can say something to the effect of, I appreciate you sharing that. It's not what I wanted to hear. And frankly, there's parts of that I understand why you feel that way. Right. But we have to be comfortable in having discussions that make us uncomfortable. It's being comfortable in the uncomfortable. And when you navigate that juror that's hostile or saying something to you that is attacking you, if you can do it gracefully in a way that honors that person and respects their individuality and their beliefs, even though you disagree with it, if you can navigate that relationship, you are elevating yourself as a really good leader, as someone that can be trusted and someone that is safe with information that you're willing to share.
Have you ever had a juror that came out with something that you weren't certain how to turn around? Or, I mean, you can obviously say, thank you, that's not what I wanted to hear. And I respect you for saying that. Yeah. But
well,
have you ever...
where it comes up, where that happens, Cash, is when our minds start future tripping, the anxiety is overcoming us and we're not present in the moment. And instead we are future tripping about what we have to do next. And we're no longer present with the person that's talking to us. Because if you're present in the moment and you're just like listening to them at a heart level with honest communication, you can never be caught off guard. You can never be caught with something that leaves you tongue-tied unless you're trying to hide something or advance an agenda. And once we slip into that mode, you're at great risk of losing the trial, which is where we naturally are all the time. Does that make sense?
Yeah. Oh, yeah. No.
And so if someone says something that is terrible, which I've gotten to the point where there's nothing. All right, here's a cliche, a saying. The things that we cannot talk about are controlling us. Another way of saying it, you're only as sick as your secrets, right? We are carrying with us things that if we're not healthy or not comfortable with who we are, or we don't understand the bigger picture, we are afraid to talk about certain things. And when we are confronted with those things that scare us and we shut down or we run away from it or we don't address it head on, we have validated it to the extreme. And so if you are confronted in jury selection with information or an answer you don't like and you don't know how to handle it, you have just shown the jury that's it. That's where this person's trying to hide something and they're not being honest. So you have to anticipate all of those things that are going to come up, and you have to be comfortable talking about it and owning it. And that might be experience. It might be focus groups. It might just be, not future tripping and just being present with the person. But I would say anybody out there, throw me something, a question of something that along the lines of what Cash is talking about, and we can see, how you could handle it.
One of the questions is, are there ways that we can practice being comfortable with discomfort outside of the courtroom?
Gosh, what there are a lot of great, so there's incredible training programs where you get up on your feet. And the one that, of course, I'm getting ready to spend 2 weeks of my life there in a couple of weeks. I'm heading out. It's the Trial Lawyers College. There's the Jerry Spence method. There's a lot of programs that are based on doing instead of just having a CLE where people get up and talk. Improv was all the rage about 10 years ago. It still might be, I don't know. But improv would force people, it's scary, right? The fear of public speaking outranks the fear of our own death. We are that terrified to get up and talk because we're going to be embarrassed. We're going to be rejected, right? It hurts. We're going to say something stupid. I've seen people trip and like mangle themselves catastrophically, but they're so embarrassed they fell, they will get up and limp away and pretend like they're not hurt because of what we're talking about. And I think that the trick to being comfortable in public speaking starts with being comfortable with who you are. The trick to being comfortable with public speaking is the challenge of being comfortable with who you are. And we carry with us deep insecurities, fears, responsibilities, the weight of the knowledge that inhibit our ability to be a natural communicator. And until we're comfortable with this weight, with this burden, it's really hard to get to a spontaneous, creative, expressive emote that is from the heart. And I love the question because that's the journey. That's you have to figure that out on your own of how do I do it. But the fact that you can admit it and say, I don't know how to do this, how can I do it, tells me that you're well on your way to figuring it out. And you have to be willing to fail. You have to be willing to take massive risk. And you have to seek the knowledge, which we all want. We're all in search of knowledge. It's never ending, right? We all want it. We all want it. And so the sooner you begin that process and journey, the more adept you'll become. And each time you go deeper into the process, you get better at it. And that's the best I got, man. Standing in front of a mirror. There was a time in my life where I couldn't look at a mirror. I hated who I was. I had zero confidence. And I was probably, suffering from a mood disorder. But I couldn't look in the mirror. How in the hell am I going to go into court and be a good advocate when I can't even look at myself, right? These are things that we move through in life that we have to address and deal with. Practicing in the shower or listening, Jerry Spence would listen to, is it Graham, one of these like really artful Southern Baptist, I don't know, like a preacher, like some guy. And he would mimic and practice and imitate this really talented public speaker. And he would just do it by himself, right? There's any number of ways that we can try and learn how to communicate.
Okay. Another question is, a worry for any trial lawyers that we come across as manipulating the jurors with emotion, especially since we're the ones asking for money.
Mm-hmm.
So how do you navigate those internal feelings when you're in the courtroom so that you can effectively tell your client's emotional story?
Yeah. Hey, Mike. So emotion in the courtroom is a big deal. And understanding our emotions is where it has to start. And I've tinkered with emotion and what works for me. But I think personally, and by the way, I don't think there's any right or wrong answer to this, but I think personally, if we go back to what I said about meeting people where they are, which is at first they're suspicious, they're not going to want to give a lot of money, if any at all, then that's how we have to meet them. And we have to slowly come along with our emotion. And it's not going to be in jury selection. It's not going to be an opening statement. It's not going to be in direct examination, right? So when do we come out with the ask, or how do we even do it? There will come a point in a trial, if you are in tune to the energy of the room, where you will know that you now have, it would be inappropriate not to express the emotion that is needed to express the righteousness of this cause. And this is kind of hard to talk about, because we know that conclusions are stronger when they're reached independently, right? I don't want someone telling me what to do or how to do it. And we know that decision-making is 100% emotional. It's not logical. We need to make the decisions at our own speed, and it will be an emotional decision. Like, how do you know when that time has arrived for a group of people? If you role reverse, if you try to understand where the average juror is at in this process, in jury selection, they're sitting back and they're judging you, and they want to know who you are. Are you one of me or you one of them, right? There's this tribal sense that's going on, particularly in this divided world we live in, where Republicans would swear Democrats are leading this country to hell, and Democrats would swear Republicans are leading this country to hell. And as a trial lawyer, the stronger connection you can make to everyone, the better off you're going to be. The more relationships and understandings you have with more people, the better you're going to understand where people are and form a relationship. I hope that makes sense. Sensitive to the infinite needs of what it's like to be, the one Black person in this whole room, or the you name it, okay? You name it. The stuff that the jurors are bringing in there, and the sensitivity of my understanding of, the person who's being talked over and disrespected, the person who wants to just pound their opinions out because they're triggered by something that's happening right there. The better we're able to make those individual connections when they come up in the courtroom is desperately needed for the lawyer to better understand the group. I'm trying to answer your question, Mike. But early on with the emotion, it's not my emotion that I'm concerned about. It's the emotion of the jurors, and allowing them to get, and being respectful enough to give them the space so that they can get there on their own. My need is to use logic to sequence the plot of the trial, to build the energy and the emotion so that folks get there on their own. And for me to be able to recognize at this point, I now have the permission to go in and express my emotion at an appropriate level. And I think there's this connection to this, is that we're professionals, and jurors expect us to behave professionally, and it's you don't want to go too far with it, and you need to time it so that it's not too early. Oh, I feel like that was a really
Well, I think we're supposed to take another break. We have one more sponsor. So So are we ready to do that? Are we there, Ginger?
Yep, I'm bringing in Rachel right now. Should be with us in just a moment.
Great, thanks.
Hello. Can you hear me?
We can hear you, can't see you yet.
I don't know why my camera's not working. I guess you guys won't get my face today.
Okay.
Oh, wait.
We feel cheated.
Here we are. Hello, everyone.
Welcome.
Thank you.
So I was going to say On Point Legal Nurse Consulting is your one-stop concierge service for helping you to understand your client's own medical records. They can add so much value to your client's case. I know, just by way of example, years ago, I had a client who allegedly OD'd and was taken to the hospital. The insurance company found out about it, and they were just gloating and saying, oh, you have a drug addict client and all this complaints about pain and suffering from the low back injury. It's just drug seeking behavior. But with a legal nurse consultant, we were able to realize that it was really the client taking over-the-counter medication, the doctor over-prescribing medication, but not listening to the client's pain complaints. And we were able to show that it was basically a doctor prescribed overdose that led to an ulcer, and that pushed us way up into the six-figure value from just a small case into a very large case. So that's one of the things that you can help us with, I know. Can you tell us other things that On Point does?
Of course. Thank you for that intro, Cash. So On Point, we are a full litigation support firm. We've been around for about 25 years, and we do everything from medical record retrieval and organization. We go ahead and retrieve those records for you, organize them, OCR them, and send them back to you. We also do a lot of consult work where we have a big nursing program where we do chronologies and timelines. So we help teach you guys how to walk through your records and how to look at them in a certain way. We help also identify red flags, which can also help you guys connect to your juries a little bit more with your emotional sides. And then we also have our nursing home and long-term care plan. So we do a lot of merit screenings, and we can help get specific experts that know the standards of care and guidelines in your ball or in your court. Then we also have our expert program. We can connect you with different experts. We have experts nationwide. And then a little part of what you were discussing were the pain and suffering reports, and that is a part of our damages program. So we also do economic damages, which is the pain and suffering analysis. And then we also have non-economic damages or economic, which are life care plans and our medical cost projection.
So I know you've made a big believer of John Romano with your pain and suffering analysis.
Yes.
Yeah, so that's great. I'm looking forward to using something like that in the future. So be sure to put your contact information up, please, in the chat session so people can reach out to On Point.
Absolutely. Thank you.
Thank you. Eric.
You know, there's a really good question from Joel. How do you make sure you speak in terms of candor and conviction, but not in a way that's downward and disrespectful, I suppose, or at the appropriate level? And there's two kind of, well, first of all, let's talk about direct examination for a second. It's disrespectful to the jurors to ask questions in a routine way. And the struggle with direct examination is that we're asking questions that we already know the answer to. So we stop listening and we stop having an honest emotional reaction to the information that's coming out. And it becomes something less than powerful for the jurors as they're watching this interaction. And
Well,
so
we've also heard the answer so many times, right? It's kind of
Yeah,
hard sometimes to just react.
That's right. You know, we know what the answer is. We know it's all scripted. The key to a good direct examination is to relearn what you already know and to move forward with curiosity in a way that you're hearing it, just like the jurors are for the first time. And my emotion, my communication is honest and not talking down, right, to a witness. So the question might be geared towards jury selection or cross, but how we talk to our own witnesses is critically important as well. On cross-examination, I really think there's two things that I want to say right now. One is you start out with the assumption that they're going to be honest and tell the truth. Think about that. We walk into this encounter with so much baggage. It's the most hated defense expert that we've known. They come in on every case and we hate them and we're going to show them and we're going to tear them apart. That's not the way you go into that cross. You go into the cross friendly, open, unassuming. I'm going to assume you're going to tell the truth. That's meeting the jurors where they are, because they're going to look at this expert. They have no idea the baggage that you have or who they are. All they know is that it's an Ivy League educated doctor who's making a ton of money and they have to know what they're talking about. And so that's where we have to start out. And you have to visualize your emotion of how you want to appear as this thing goes in advance through your chapters and sequencing of your questions. And at some point in cross-examination, their lies, their dishonest interpretation of the facts and zeroing in to misleading levels of detail will be fully exposed. And the way you don't become disrespectful is that you have to have common sense and be able to know that the jurors, at what point are they recognizing the deception that the defense is now using? But we have to let the jurors get there before we do. And if you do that, you won't be disrespectful or condescending. In jury selection, to that, the answer to that question is we have to start working on our listening skills. You go to a doctor and you leave feeling humiliated and degraded because nothing happened in there that you felt like was heard or understood. That's how we are as a profession as well. We don't know how to listen and respect and appreciate what's being given to us. And I think that if we just listen with our hearts, we will never be disrespectful if we're giving an honest answer back.
Oh, I'm just thinking through this. It's a completely different approach than what I'm used to doing, but I like it.
So are there ways that we can practice being comfortable with the discomfort outside of the courtroom? We carry with us a lot of baggage and we have so many blind spots. And this is going to be autobiographical. This is my story. I grew up in a scary environment. There was violence, there was emotional abuse. Every week, my parents were going to get divorced. My mom would throw us in the car. We'd drive down the road. 5 minutes later, we'd turn back and go back in the house. I grew up in a home where I did not know how, as I grew up into the world and left that environment, I didn't know how to trust and love when I could get hurt. At superficial levels with people that couldn't hurt me, I could be trusting, vulnerable, and open, like almost to a fault. But if I had skin in the game, I could never let my guard down. And that made me unlovable because I didn't know how to love. And I hurt a lot of people, including my kids, my ex-wife, and my current wife, who I get uncomfortable when because she doesn't have that baggage, and she's very expressive and emotional, and I just shut down. And I want to go back to the question, because I think there was a point to this story. Are there ways you can practice being uncomfortable? You have to know what is making you uncomfortable and why. You first have to identify the source of the discomfort. And then I think you need to seek it out and lean into it and try and understand it and be willing to open yourself up to explore it. And so what is it that makes you uncomfortable? Is it the fear of failure? Is it imposter syndrome? Is it my life is so disorganized, I don't have the ability to properly prepare? Is it that I've never won a trial and I just don't think I'm ever going to win one again? Right? Identifying the source of the discomfort is the key to overcoming it. And if it is as simple as, it's the number one fear, right? Or reptiles might be number one, but whatever, it's up there. The fear of public speaking and being uncomfortable. If it is simply, I just don't want to fail, I just don't want to lose, I think the solution is simply being the best me I can be today to prepare for the case tomorrow. What do I need to do today to be the best me? And so long as I do my job the best that I can, whatever happens down the road, I'm going to have to be okay with it because it's beyond my control. And recognizing that the fear, that uncomfortableness is going to come, and just know that your heart will keep breathing, your lungs will keep pumping, the blood will continue to circulate through your brain, and you'll get through it. We just have to keep going and doing the best we can.
So you spoke earlier about recognizing when the jury is ready to hear you say, okay, there's been injustice here and this is what I want. And you indicated that you would acknowledge that at that point during the trial. So I'm assuming we're talking even before closing. How do you acknowledge that at that point? How do you do that?
Well, it's a sense, if I'm in tune to the trial and myself, and I'm like healthy, and I have a good understanding of who I am in that moment, I'm better able to guess and understand where other people are. And I talked about role reversal, right? Really honestly understanding where people are at that moment.
It'd be impossible to do.
So I didn't mean so much as recognizing the moment, but then acknowledging the moment. How do you acknowledge it?
What do you do? I can just sorrow. It's like, wait a second, you teach at the University of Washington. You are teaching young doctors to go out and help the community. I want you to look this jury in the eye right now and tell them da 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 da. So I could use sorrow, which is a form of outrage, maybe anger. I could just my facial expression of anger or disappointment. There's a fine line between the duty to entertain, which we have to keep the jury involved. We have to keep it exciting, and we want jurors, what's he going to do next? This is exciting. I can't wait to see what's going to happen. And crossing that line into like inappropriate theatrics. That moment when it's, like, come on, dude, are you fucking serious? That's what you're gonna go with that party line right now and say that. How I react in that moment and show it, I think will depend on those circumstances and my relationship with the jury, the judge, the defense lawyer, myself in that time, because emotions are changing. And how I react to a situation, there's no like formula to this stuff. And my emotions are going to change based on who I'm talking to and who I am at that time. But as long as I'm, like I said, honest and know where I am at that time, I will be willing to show something that will be raw and sincere.
Well, it seems like you've been raw and sincere throughout. Really, I mean, isn't that's what you're trying to say is we have to be sincere. We have to start empathizing with the jurors from the get-go, not just our client. But now we've got the jury on our side. Your let's say it's during cross-exam. It's suddenly you've turned the tide. You've cross-examined the defense doctor, and the defense doctor has given you this opening. You realize you've got the jury now. So, and I realize maybe it's just not a fair question, but I'd love to watch a couple of your trials and have you identify that moment where you say, okay, this is where I just uncorked it all and pulled the jury over to me at that moment.
You know, Cash, so there's a saying that after jury selection and opening statement, the case is going to be won. What winning means is radically different, because you can win, but be sent home with a verdict that doesn't cover your costs, right?
Absolutely.
The emotion, the feelings that the group will decide in the verdict room for their definition of justice, so that we really, really win and win big, is tying into what you're saying. And there's this saying that the closing argument, you're not going to win the case in closing argument, but you can lose it. The parlay of all of this amazing process, right? This complicated, interconnected web of the jury trial, where every stage is connected to each other. And what happened before is dependent on what happens next, and what happens next is what dependent on what happened before. And the development of our case and sequencing and plot and all that, this is complicated stuff. What you want at the very end, in your last breath, as you sit down and there's nothing else you can do in this search for truth and justice, right, is the handoff, where I'm now passing off this case, this search, this cause to you. The last thing we're doing is to empower the jury to make the world a better place, to make it safer, to enforce accountability. And it has to be connected to some greater cause than our clients are vehicles to justice, right? The case has to be attached to something I describe it as a spiritual search, that yes, our clients are the ones that need to be compensated for this loss, but the message, the meaning, the importance of the verdict is to make the world a better place. And we can only inspire other people to reach that point if we have it within ourselves to give that away, and not in a way that is telling them how to do it and what to do, but rather being a part of the process and a member of the group, so that collectively we arrive at that point.
No, I think you've hit the nail right on the head. As a young attorney, I used to just struggle, and I still struggle, but struggle with making the case important to the jury. It's not
So
enough.
that's where it's at right there. That right there will be our next talk. Okay. We have to figure out how to frame the case and tell the story. And it has to be of vital importance. And here's the key, you guys. There is so much fear and uncertainty in the world today. The people are desperate to make a difference and to do something good. And in a courtroom, we have a container where we can cut through all the political crap and divisiveness. And we have a container where we can reach 12 people who outside that room hate each other, but together, they're in this together, and they realize that we are more alike than disalike. And we can inspire this group of people to do great things and to change the world in a way that is hopeless once they walk out of there. And the meaning that they take from that process is forever, right? That's a closing argument. Your verdict will stand for something.
Yeah. Yeah. Thank you so very much. People have been writing in some questions, but I want to make sure that people have an opportunity now to put up their questions and have you answer them. So we have about 3 minutes left. Are there any questions that people want to throw up there? This is your last chance. I'm going to thank our sponsors again. Oh, here we go. Someone's asking, Mike Smith is asking, can you talk about checking in with yourself during the phases of trial?
Yeah, absolutely. Knowing the baggage that we're bringing with us is vital to connectology, to connections, to relationships. And if we're not self-aware of where we are in this moment, then we're stumbling fools. And so before you ever open your mouth as a public speaker, you have to be aware of what's going on inside of me. Am I nervous? Am I anxious? Are my kids really suffering right now? And I'm just not present because all I can do is think about their safety. Am I about ready to go bankrupt? Am I filled with joy because of some outrageous success that I can't hide and that's inappropriate to this moment? So the check-in of what's going on with me right now has to happen every time you stand before a group of people so that you can meet them where they are or not be inappropriate or not show some emotion that isn't appropriate for what's happening right then and there. That's a great question, and it's a little thing that's huge.
One of our listeners wants to, they'd love to hear or see a closing and opening that you've done. Have you, I know CVN has lots of trials. I know you have a trial just recently that would probably be shown on such a program.
Email me and I can get you some, yeah.
Okay.
What I will say is there are books on how to do this stuff, but you have to find out how you try a case.
Yes.
And I like taking lessons from other people who've done it is we have to do that, but we have to take that and we just have to learn how we express it. You know, expression is, you have to find your voice. And that's the beauty of life. That's the sole purpose of why we're on this planet, is that journey of who am I? And what are my feelings and my expressions on this issue? And that's where the logic gets in our way, is that we get away from that because we have an idea, an intellect that will betray us in that moment of expression.
Well, I think sometimes we have a definition of success. You kind of get pushed into it being trial lawyers, and that definition of success is a big number. And that's not It's not what we're in the trial
Yeah.
for, is it?
And then there's envy, there's jealousy, there's I'm not good enough. And that's the spiritual malady of this planet, of this earth, of our society, right? Is that we're measuring ourselves on some artificial attachment to an outcome. And that's where we've gone wrong.
Well, thank you so very much, Eric, for sharing and sharing directly from the heart and just laying it all out there. That's amazing talk that you gave today. Thank you.
Well, thank you for having me. I feel so, grateful for being able to share and express.
Thank you. Ginger?
Yeah, this was terrific, Eric. And I know that on behalf of all of us, we cannot wait to have you back. I'm already ready for another discussion. And I hate that these webinars, they fly by and they go so fast because I feel like we're just getting into it. And I cannot thank you enough for your time today and for being here to share your experience with all of our attorneys who are watching. Cash, I hope you know how much you're doing so much good by helping everybody today. And I'm just really looking forward to the next one that we do soon. I am about to share my screen just for a moment because I want everybody to either maybe take a picture of this or just keep an eye on your email because I'm going to send this over to you. So that way you can stay in touch with Eric and Cash and all of our incredible partners at On Point, HMR, and Fox AE. We're so blessed to work with such a great group of people. But I will email this to you so that way you can stay in touch. And like I said, if you have any other questions, please stay in touch with Eric and Cash. And then also our good friend Ted over at HMR was not able to join us today, but he did tell me who the winner is of this special coffee giveaway. So if they are still watching, I hope they are. I want to congratulate the winner of today's HMR coffee giveaway, who's going to win 4 bags of this freshly roasted coffee. Da, da, da. Congratulations to Kelly. Kelly, myself, and Ted, we will reach out to you after this webinar. We hope you enjoy this coffee. And don't worry, guys, like I said, there's always more chances to win. So I have a webinar that I just put up on the website, which is going to be on Tuesday. It's going to be great. So go ahead and check that out. And then we just confirmed one that's going to be on Wednesday next week as well at 3 o'clock Eastern time. So we got tons of webinars. If you guys know anyone that you would like to nominate to come speak with us, or if you'd like to speak yourself, just send me an email, send me the topic, and we'll get this going. Because as you know, there's nothing better than helping each other. And I still can't get over how good today was, Eric. Thank you so much.
You're welcome.
Thank you.
And I'm just enjoying these comments that are rolling in, you guys. Thank you. Eric, I hope you see this right now. Everybody is so grateful for your presentation. And I'm just blown away.
Yeah.
All right, guys. Do you have any closing comments before we head out?
Follow your heart.
Gosh.
Thank you for
That's
just
right.
giving us a whole new way to look at it. Doing a trial, and I know some folks are like, yes, we can't be you, Eric, but we can still take so much from what you've shared with us today. And I think just the number one point about empathizing with the jurors, what they're coming into, I think it's going to help me tremendously. I love the line about, what's worse, frivolous lawsuits or corporate greed. You gave us a lot of little pointers, just even throughout, besides the big picture of making sure that we put our emotions out there and we become at peace with ourselves before we go into trial. So thank you so very much.
You're welcome. Thank you.
All right, guys, we will see you back here again next week, but hope you have a wonderful evening and have a very happy Memorial Day weekend. If you need anything, just let us know, but take care. We'll see you soon.
Thanks
Bye,
to
everybody.
our sponsors again.
Thank you.